Thank you, counsel. We'll call the next case, which is COSTA versus Downs Development. Counsel, are you ready? Okay, head on up. Take your time. Go ahead.
Your Honors, my name is Chris Draper. I'm with law firm Becker and Polikoff, and I'm representing the appellants Douglas and LINDACOSTA today. What this case, I believe, essentially boils down to is that the COSTA entered into a contract, a pre-construction contract to purchase a condominium that had not yet been constructed by Downs Development. Under the contract, they were entitled to all notices being sent by certified mail. They were also required to put a second earnest money deposit down upon receipt of the written request. There was evidence at trial that a letter was drafted dated August 15th of 2001, which required the second deposit be made, but that was not received. Unrebutted evidence is it was not received by my clients. The COSTAs did get a certified letter on August 27th of 2001, 9 days after the letter was written. The letter was still dated August 15th. It was just postmarked and mailed 9 days later, received by my clients August 27th, certified mail. That letter said, in essence, it is now time for the second deposit to be made. My clients, when they received that letter, the testimony in the court was that the letter was received or signed for the 27th. The next morning, they called the sales agent to inform them or to inquire as to whether the sales company would prefer they send several checks because they had to have it from different accounts. Then, in fact, the testimony was that they said, we can either send you several checks now or combine the money in one account and send one check in a few days. That message was left with the sales agent, who they had been dealing with continuously for the approximate year and a half since they had signed this original contract.
Mr. Draper, let me just interrupt for a moment. Doesn't this case boil down to the trial judge disbelieving your client about whether or not he received the August 15th letter, and secondarily about when there's no doubt about him receiving it, August 27th, instead of sending a check the next day or two, he waited almost 10 days or 2 weeks? Isn't that the bottom line of what happened here?
Your Honor, I don't believe it's about the credibility, because all of the testimony was that the terms of the contract were that the deposit would be made upon receipt of the letter. There was never any testimony whatsoever that that letter was sent on the 15th. The lady who Mr. Downs said he instructed to send it, Philomena Gregorian, not only did not testify that she ever sent it, but in fact she was fired by Mr. Downs and a complaint was made against her, resulting in a 14-month suspension of her license at that same time because of her, as Mr. Downs said, her misconduct or improprieties with the escrow amounts. So I don't believe it was about his credibility on whether he got that letter. There was no evidence at all that he didn't. In fact, his testimony was when she then had called him, he had said, I will pay as soon as I receive the request.
There's no issue that he knew it was due and owing, that he knew it was going to become due at some time.
Correct.
And that he acknowledges, the best situation for him is he acknowledges that he received the written letter on the 27th of August.
Yes, sir.
And knowing all of that, and knowing based on the contract, that he used the contract that he used, that it was due upon receipt, that he still waited almost 2 weeks to pay.
Well, Your Honor, if I may.
Is that true?
It is 9 days, I believe, Your Honor.
9 days.
But if I may, the reason is he got the letter, signed for it the 27th. The next day, his wife called to ask whether to send several checks now. That is not a breach. That's not even anticipatory breach. It's not even a potential repudiation. The testimony was clear. That was what was asked. Do we send? Is it okay, or would you prefer several checks now?
Why couldn't the trial judge have viewed that in the same light that the defendant viewed it, and that is, in light of the prior conduct, the prior history between the parties, that was just another delay?
Well, because, Your Honor, the testimony of Mr. Downs was that they had two prior transactions, both closed. One of them, Mr. Costa called and asked, because closing was 1 month away. When he received the letter asking for the second deposit in a different case, he called and asked if he could bring that money to closing. He was told yes. That was it. Not that it was a problem, not that there was an issue, not that it made Downs upset. The testimony of Mr. Downs was simply, he was asked by the broker, can they bring this money to closing, and he told them yes. That did not in any way indicate to Mr. Costa or Mr. Downs there was any delay, any determination to play games. Simply, the money, we're coming to close from Fort Lauderdale to Daytona in a month. Can we bring that money with all the rest of the cash? And he was told yes. So he is complying. I mean, he asked and he's told yes, and he complies, and they close. The only other closing, which in the reply brief, in the answer brief, counsel states it's not to be looked at as though it were bad. Well, Mr. Costa's father died. He had to take care of the estate. That's the testimony. He contacted them, let him know his father had passed away, and asked to postpone the second closing. They did. They raised that as though that were indicative that Mr. Costa were a problem client. He wasn't. His father died. He couldn't make the closing.
I thought he didn't appear for a closing twice, and that was one of the times.
There was one closing, Your Honor. He had asked for the closing documents to be sent to him so he could review them before closing. He didn't get them. That's unrebutted. He then got them. They set a closing, and his father died. The Downs has admitted that that is not an issue here in this brief. They've said that they're not holding it. So his father died. Subsequently, they set a closing and sent him a letter, you must close by July 20th, and it was done. Following that, if Downs didn't want to do business with him, he didn't have to, but he entered into a third contract. And what's really critical here is that after Costa calls and says, do you prefer several checks now, he doesn't get a reply back. He has to call back, and he's told then by Philomena Gregorian, and this again is Mr. Downs' testimony, when Gregorian said to Downs on the 29th, one day after they've actually got it and called, they want to know whether you want several checks now or one in a few days. Downs' testimony was the contract's terminated. He didn't say, I want the money now. He didn't give them any time to comply. And the case law that I cited in my brief indicates, even with time of the essence, you have to give him some kind of notice.
And that was on the 29th?
Yes, sir.
And he still didn't send the money?
Pardon?
And he still didn't send the money?
Well, he had called and asked, because the 28th they called and asked if they preferred several checks or one now. Several now or one in a few days. Before that question was answered by Ms. Gregorian, they were waiting for a response. She passed that message on to Mr. Downs. He said, this is his testimony, the contract's terminated. Forget it. She then contacted them and told them, don't send your money. That was on the 30th. So between the 29th...
That would be right if the contract was legally terminated, wouldn't it?
Pardon?
That would be right if the contract had legally been terminated, wouldn't it?
I believe, yes. Had the contract legally...
So the only issue is whether the contract was legally terminated.
Correct. Was it reasonable?
As a matter of law.
Yes. Was it reasonable? The question is, was it reasonable on 2 days' notice? On no day's notice. Was it reasonable for Downs to cancel the contract? Now, the question that triggered him canceling was, do you want several checks now or wait until I put the money into one account in a few days? That was all he was asked. And his response was...
Didn't the trial court find that, first of all, the verbal notice under the circumstances was adequate and that your client had had substantial notice before it was finally put in writing? The request was finally put in writing.
Respectfully, Your Honor, the trial court, there was no testimony about that. Mr. Costa...
And that's what's in the order. That's what the trial court found.
The trial court found that they had been notified verbally by Ms. Gregorian that the contract was accepted. and that when Ms. Gregorian called to tell them that they still had to make a second deposit, that they knew of that. There's no question they knew there was a second deposit, but there was no demand made for it to be paid until they received the August 27th letter, which for the first time says it is now time for the deposit to be made. It didn't say we've begged you and pleaded with you to pay, we've requested it. In fact, there was no testimony that had ever asked for the second deposit. And Mr. Costa's testimony was he had told them, as soon as you send me a letter requesting the deposit, I'll pay it. All the other conversation was simply because it was still pre-construction. No ground had been broken. It was Philomena Gregorian just simply reinforcing that there is going to be a second amount due.
You're dealing with an experienced buyer, who I think may have been an attorney, if I remember correctly, who has dealt with this seller before, who has known since the sign of the contract that the $4,200 plus was going to be due, who was reminded in June or in August of 2000, in February of 2001, in May of 2001, and then in August they say, send us the check. And at that time he decides he's going to go ahead and see if he can get two checks together. I mean, is he saying, I didn't know that I was going to need this money, or I didn't know that it was going to have to be in a check?
No, simply when he received that, he asked them the next day, do you want me, or do you prefer me to send you several checks now?
And let's assume that they did not respond at all. Would he send the check 6 months later?
Well, Your Honor, they actually responded and told him, you're terminated, and he still sent the checks with a letter explaining this has to be a mistake. And
Did he send the checks then, or did he send the checks after the phone message and after he then received the written letter, which he said he received on the 31st?
It was actually wrong. It was mailed the 31st. That, I believe, was Friday. He mailed the checks I believe it was a Tuesday, or the letter.
6th.
Well, actually, I think there's a letter the 4th, September 4th. There was a letter saying there must be a mistake. I believe the checks were received the 6th. So Labor Day is Monday. He mails the checks with the letter saying there has to be a mistake. I can't be canceled because all I asked was whether you want me to send several checks now. And again, he got no response back. The case law that I had cited to the court had indicated, pardon me, a little dry for me, had stated that even in a case where time is of the essence, it is incumbent upon the seller, and this is a case of Lance versus Martinez from the 3rd District, to give a reasonable notice with a reasonable time to comply. The notice that was sent didn't say you have 5 days to send it, or 10. And in this case that I'm citing, a 7-day delay in getting that money was not deemed to be unreasonable.
What's your response to the argument in the answer brief that although the contract, the date wasn't filled in, it did say that the notice would be due in sometime in 2000, and that the additional deposit would be due in 2000. I mean, the contract does say that. It leaves the date in 2000 blank, but it says that the additional deposit will be due in 2000, and it wasn't paid until well into almost August of 2001.
It says second deposit due blank 2000 because they signed the contract in 2000. It's got the amount, and then underline it says upon request. And so they weren't making any requests at all until 2001. And so, and the court also found that issue was raised. The court found that there was a binding contract that did not include that June date. And in fact, Mr. Costa indicated, Mr. Downs testified that there was no attempt in June to enforce that. In fact, he executed the contract, and it said it was accepted on the terms and conditions offered by the buyer. That's the testimony. He then wrote in a June deadline, which the court did not upheld. They found the contract to be a blend, essentially. It was his signed acceptance of the terms of the contract. There was no provision for a June payment to be made. So when that request was made, all of the requests under the contract, and again, while Mr. Costa is an attorney, Mr. Downs is a real estate developer. His contract specifically stated they're entitled to written requests, and it's got to be certified.
A request or notice?
Written requests, and this contract actually requires certified mail.
For all what?
For all notices.
All notices?
Yes, sir.
And your view is that a request for payment is a notice under the contract?
Yes, and that's the way it was treated. When Mr. Downs testified that he asked her to send the notice, he specifically said he required it be sent certified mail. In fact, he testified he was upset that it wasn't sent certified mail even, and that he instructed Ms. Gregorian to send it again certified. And that's what caused the biggest problem, was a certified letter dated August 24th is received August 27th, but the letter saying we need your money is dated August 15th. It was my client's position. Ms. Gregorian never sent that August 15th letter. That's one of the reasons she was fired. Mr. Downs never even called her to testify whether she sent the letter either. All of the evidence was the only letter that was ever sent was dated August 15th, for whatever reason held for 9 days and then mailed out certified and received by my client the 27th. 2 days later, he gets a note that his contract's been canceled. Not, I want the money now, not, I don't want to play games, not, you have 5 days, not what the case law says, you have to pay within a reasonable time or we're canceling. Simply, it's canceled, we won't take your money anymore. And that's why there was a delay before he wrote the letter and said there must be a mistake, and right after Labor Day, first business day after Labor Day when the post office was open, mailed that check, which was actually received along with his letter.
And it's your position that as a matter of law, the trial court could not have found that the 3 or 4 days before notifying them the contract had been canceled could not be reasonable?
Correct, Your Honor. And it was, to be honest, it was 2 days. They got the letter. It came in certified mail the 27th. On the 28th, they contacted Downs about how to mail the money, and on the 30th, without getting any response, they called back, and that's when they were told, Mr. Downs has terminated your contract. So it was really...
I thought that was the 30th.
The 30th...
The night of the 30th.
Sometime...
So on the 29th, Gregorian calls again and leaves a phone message asking again for the deposit.
Right.
On the evening of the 30th,
COSTA
Downs
called.
decides to cancel the contract, and that's the night they notify him.
Right.
So in order for you to prevail, you have to convince us that as a matter of law, that amount of time was unreasonable.
Yes, ma'am. And the reason I say that is the case law holds that 7-day delay is not reasonable.
Well, it depends on the circumstances,
Yes,
doesn't
ma'am.
it? It depends on the relationship of the parties, the prior conduct, all of that sort of stuff.
Correct.
How can we tell the trial judge that as a matter of law, this 3-day period of time was unreasonable?
Because for one thing, Your Honor, the law, the case that I cite you, requires that the notice give a reasonable time for payment. This one did not set any time. The second is that in the circumstances, the totality, there have been 2 successful closings. This is a third.
Well, that sounds like an argument for the trial judge, not for us.
Well, Your Honor, I'm showing you why the court should have found that this cancellation was, as a matter of law, unreasonable. There was no time set. The case law requires the notice set sometime. When my
If it doesn't set a time, it has to be reasonable. It doesn't have to set a time. It just has to be a reasonable time.
And Mr. Downs testified he had let other people, in fact, this is in my brief, wait as long as 20 days before they paid their second earnest money, that he testified that he recognized at the time he said terminate that contract that they were trying to pay.
Couldn't the reasonable time have been back from May 2000 and right after the contract saying, we're telling you it's due, we're telling you it'll be upon request, we're going to give you time to do it, and then in August of 2001, he says, okay, we've given you a reasonable time, now we need it.
Yes, but Your Honor, he has to give him at least some time to get the funds. Theoretically, if they had gone to the bank the 28th and gotten the funds and put the funds in the mail, they probably would have been there about the 30th, a couple of days for mailing. He canceled the contract when he was simply told by the sales agent that they had called to ask whether they preferred several checks now. They were trying.
That was orally?
Yes.
But that's not any good from what you're telling me, because they can't do anything orally. It has to be by certified mail.
No, the notice to pay has to be by certified mail.
Doesn't the cancellation have to be by certified mail, too?
It had to be, yes, and it wasn't done until the 31st. So they got literally 2 days to pay. And, in fact, they were not breaching the contract. They were simply asking whether Downs preferred several checks. Now, that's the testimony, too. They were asking, do we pay you several checks right now, or would you prefer one in a couple of days when we move the money? Their response was, You're terminated.
You do concede that they could have sent money on the 28th.
Yes, several.
They could have sent money on the 29th.
Yes.
They could have sent money on the 30th.
On the 30th, they were told.
But they didn't send money on any of those 3 days.
No, ma'am, but on the 30th, when they called Ms. Gregorian, that's when they were told, your contract's terminated, don't send the money. So they literally had 2 days to either send the money, but what they did was they called and asked which the preference was. They didn't get a response back, and they got terminated.
You've got a minute left for a rebuttal.
Well, then
You'd like to use it?
Yes, Ashley, I'll hold it.
Okay.
Good morning. May it please the court. My name is Van Catterton. I represent the LA Downs Development, the seller of this transaction. What the appellants are essentially asking this court to do is to look at this case in the vacuum of the events of August 2001. The court has correctly pointed out that reasonableness of the time for payment of this deposit depends on the circumstances of the case. What the Hornbook law says, which we unfortunately have to resort to here because there is no case out there that precisely mirrors the facts of this case. What the Hornbook law says, what the legal encyclopedias say is where the contract is silent, reasonableness of the time for which to perform is going to depend on a number of circumstances. The subject matter of the contract, the party's intentions, and the circumstances attending performance. And the circumstances attending performance here are exactly what the seller took into account in making the decision to terminate this contract. We are not here to argue that cutting a contract off after 4 days, other circumstances notwithstanding, is a reasonable thing to do. It's a very brief period of time. The case that was cited by appellants referenced the Lance case, where the court said it may be as a matter of law that 7 days is a reasonable time in which to pay the deposit. That depended on the circumstances of that case. That was an acceptance revocation case where the seller gave the buyer no notice at all that the contract would be canceled if the deposit was not paid.
Let me ask you this. If there had been no prior oral request for the deposit, so that the first and only request for deposit was the certified letter that was received on the 22nd, would you agree under those facts that that period of time was not reasonable?
It may very well not be, and we can recalibrate the facts here and take off factor after factor. I think you're correct. It probably wouldn't be reasonable under those
The
facts.
trial judge finds that there were telephone requests for the deposit. He says that in his order. What is the competent substantial evidence in the record that would support that finding?
We entered a timeline prepared by the seller's sales agents under the
It's in
business record
Exhibit
exception.
6, I believe, correct?
I'm sorry?
Your Exhibit 6?
I'm sorry, I don't know the exact number, but it was a one-page timeline that was prepared at the direction of the Downs development principal, Tom Downs, by the sales agent, and was entered under the business record exception to the hearsay rule. And the comments by Mr. Costa were, of course, submissions by an adverse party. That is the evidence we relied on to establish that timeline. And that was not disputed at trial. To the extent that there may have been conflicting evidence on that, certainly the trial judge was at liberty to draw his own conclusions based on his observations of the demeanor and the credibility of the witnesses. And I frankly think this case underscores the importance of deferring.
So that was admitted as substantive evidence, and
Yes,
it is
sir.
defendant's exhibit. It wasn't just a tool that you used to...
No, sir. Once that was admitted, we found it unnecessary to call Ms. Gregorian personally because from our case's perspective, that established the elements that we needed to establish. Even so, Your Honor.
And that says, for example, that on August 9, 2000, there was a phone conversation regarding the deposit in which the plaintiffs were told that the defendant was still waiting for the deposit. The response was that the closing is still 2 years away. I mean, that's the document you're talking about.
Correct.
And
Yes,
it goes on with different elements of the time.
Now, in addition to that document, Mr. Costa himself acknowledged, although somewhat tortuously, that those conversations had occurred and that he had been asked for the deposit. Even though on direct examination, when he was asked by Mr. Draper, Mr. Costa, did you ever receive any request prior to August 2001, verbal, telephonic, or in writing for this deposit?
Where did he admit that he was asked for the deposit? Because in what I saw, he denied that he was asked for the deposit. He admitted that there were phone conversations, but his take on it was that the person was just telling him that at some point in the future you would still need to make that
That's
deposit.
correct. That's exactly correct, Your Honor. There was some amount of dissembling, I believe, by Mr. Costa on that issue. And in fact, he did say, well, it was discussed. He said everything on direct except that it was requested. But on cross-examination, Mr. Costa was unable to explain why, if the deposit had not in fact been requested, why was he then telling the sales agent, hey, you put the request in writing, I'll pay the deposit. This happened during 2 telephone conversations. The odd thing about this is, during this week in August, if the Costas had not made this phone call, If they had not left this phone message saying, hey, we have insufficient funds in one account, we need to either consolidate funds, send a few checks now or one check later on, if they hadn't made that phone call, I don't know that we'd be here today. Because if instead the COSTA had received that written request on the 27th, on Monday, sat down at dinner and said, well, Downs is looking for his additional deposit. We're going to take some money from the vacation account or whatever, move it over. We'll send him a check, take a couple of days. If the check came in a week, I don't know that Downs could argue what we're arguing today. But with these buyers and with the past history that Downs had experienced with these buyers, that phone message to Mr. Downs, correctly so, I believe, was to him.
Let me ask you about that past history. The police counsel says that history was simply that there was one request. In other words, there was a request for a deposit that was a month away from closing. There was a request, can we just bring the funds in closing? And the answer from the defendants was, sure, that's fine. And with respect to the second contract, you heard what he said, but
Sure. Here's what happened in that prior transaction. There were a number of disputes, complaints, and arguments from the COSTAs on that first transactions relating to closing. They argued they shouldn't have to close because they didn't receive the closing package 2 days in advance as had been requested, and which was being given to them as a courtesy. They didn't have to close because the CEO hadn't been reported. They didn't have to close because the closing package was sent to the wrong address. They didn't have to close because they didn't get adequate close. None of those things in and of themselves are fatal. They happen in every closing. There's always arguments and petty little things like that. More to the point, in the prior transaction, there was in fact a dispute about the fact that the COSTAs had failed to pay the additional deposit in that transaction as well. And it reached the point, it wasn't just a simple matter of one request, okay, we'll pay it. It was a matter where Downs had to instruct his attorney to send a letter to the COSTAs, and that letter's on the record, telling the COSTAs, if you don't pay this deposit, it's going to be canceled. And Mr. Costa responded to that one by saying, well, look, closing's just around the corner. Why don't we bring the cash to closing instead and pay it off once? By that point, Downs, as he testified at trial, was simply worn out. He said, fine, I like we just get it closed. That's what happened in the first transaction. Now, in the second transaction, and we have a unique case here because the transactions overlap. We have the first contract signed, second contract signed, closing on the first contract with all its attendant problems, and then the termination of the second contract. In the second transaction, contract signed in May, as the court correctly pointed out, regardless of which contract we're looking at, there was a clause in both contracts that said the deposit is due and payable on or before blank 2000, and then the typewritten words upon request. Okay, so there's at least an implication it was due in 2000. August 2000, sales agent calls, we need the deposit. February 2001, sales agent calls, we need the deposit. Mr. Costa made a variety of comments in response to those calls. Number one, well, closing is only going to be 2 years away, so I really shouldn't have to pay the deposit. Construction hasn't commenced yet, so I really don't want to pay the deposit. Never mind that neither one of those objections were conditions preceded in the contract to pay the deposit. At one point, Mr. Costa tells the sales agent, don't worry about it. Hey, I'm a lawyer. I know what I'm doing. But specifically what Mr. Costa tells the sales agent is, hey, you put it in writing, I'll pay the deposit. August 2001, seller puts it in writing, mails it out by regular mail August 15th. The Costas claimed not to have received this. What the court said in its final judgment was not that the Costas didn't receive it, but simply that the Costas testified they didn't receive it. There's no dispute whatsoever, however, that the Costas did receive it on August 27th. This was because when Downs learned a week after the original mail-in that the sales agent hadn't sent it by certified mail, says you need to send this by certified mail, not because the contract required it, which everybody acknowledges and nobody disputes, but rather because, as Downs testified at trial, he thought he was being gamed by a sharp attorney. The sales agent resends the same letter, same date. They acknowledge receiving it on the 27th. There was no scheme here to sandbag the buyer by holding on to this letter. The same letter was simply resent for the postmark 9 days later. Despite Mr. Costa's promise to pay the deposit upon written request, what does he do? Did they put a check in the mail? Did they put 3 or 4 checks in the mail? Did they invest in a 39-cent stamp and send these things up? No. The next day, they leave a phone message. Insufficient funds in one account. We need to move some checks around. Tell us what you want. The next day, contrary to Mr. Draper's statement in his argument, the sales agent calls and leaves a message renewing the request for deposit. That's a Wednesday. Thursday, the sales agent advises Mr. Downs of the substance of the Costa's phone message. Downs hears this story about insufficient funds. They have to move some money around, 2 checks now, 1 check later. As he testified at trial, that's the point where you throw up your hands and say enough is enough. Call him and tell him the contract is canceled. The sales agent did so on Thursday night, mailed out written notice on Friday by certified mail. Now, the Costa's first response at that point is not to send the check. Mr. Costa sends an argumentative letter up to Downs' attorney arguing postmarks, including copies of envelopes, arguing the unreasonableness of the termination, notwithstanding the long history of these parties that preceded that. Everything but the check. Not until a couple days after that did the Costas finally send in the check. Now, the buyer wants to argue that these telephone requests are invalid, but the fact of the matter is we have to remember this is a case where they're asking for the extraordinary, equitable remedy of specific performance. The buyers want everything their way here. They extended no good faith or reasonable cooperation with the seller at any step of this transaction. They want to argue the telephone requests are invalid. At the same time, they introduced their own testimony at trial that they relied on telephone notice from the same sales agent who requested the additional deposit, advising them that the contract was accepted. These buyers sat on a contract that didn't hear the seller's signature for over a year until suit was filed and they obtained it through discovery. It's okay for that when it benefits them, but when the seller wants something from the buyers, suddenly the out comes the microscope and we're looking at the fine print.
Mr. Catterton, let me try to synthesize a little bit what you're telling me. You're indicating that in August, in February, and in May, there were phone conversations telling him that these items were due, but you acknowledge they were not followed up in writing. Is that correct?
That's correct.
And you also,
perhaps not in May, Your Honor, but we know in August and February they were requested.
and you acknowledge that in at least one of those conversations, it may be that Mr. Costa said, send it to me in writing and I'll comply, but that was never done.
Sure, that's correct.
And then the first item that was actually sent, and again, I'm having a little trouble understanding this, are you contending that it was sent in August 15th? Or are you agreeing that it was not sent in August 15th? Or if it was sent, it was not sent in a sufficient format, i.e. certified, and therefore the letter we need to be looking at is the one that would have been sent on August 27th?
No, sir, we did not concede that the August 15th letter was not in fact sent. All we concede is that the Costas testified they didn't receive it. We know from the timeline and from the fellow sales agent that there was a regular mail notice sent on the 15th. For purposes of discussion today, we can assume, let's assume for purposes of discussion, that the first one they received was on August 27th. This is not a situation where we can look at that 1 week in a vacuum. As I said before, what's odd about this case is if the buyers hadn't made that phone call and left that message, you know, Downs may have just, a week might have gone by, and if the check came in, Downs would have been fine. We're presuming a lot, I think, to assume the check would come in because it didn't come in this case until after the contract was canceled. Now, the buyers proposed arguments at trial that the
Yes, other than Defendant's Exhibit 6, which is the timeline, was there any other evidence that you presented that the August 15th letter was mailed on August 15th?
No, sir, other than Mr. Downs' testimony that that's what transpired.
Directed. He directed that it be done.
That's correct.
That was his testimony.
That's correct.
Okay.
And he had asked the sales agent, according to his testimony, on a number of occasions, have we got the Costas deposit yet, because it was getting red flagged by the lender. I believe that's what prompted the phone message. The buyers had argued here that there was some scheme by Downs to terminate this contract or any contract, whatever it took to do that, in order to resell the unit at a higher price. Putting aside for a moment the fact the trial judge specifically found there was no credible evidence of the value of the unit at the time of breach, what we have here is an argument that Downs was doing this to resell it, while at the same time the buyers were arguing at trial, well, Mr. Downs, isn't it true that you extended flexibility to other buyers, gave them additional time to pay deposits? And that was in fact the case. These were faults where reasonable circumstances justified that extension. Those circumstances did not apply in the Costas case. But the buyers can't argue here there was some scheme to resell it when in fact they're eliciting testimony just to the contrary, that he's extending contracts, just not the Costas. The buyers want to argue here that somehow they showed they were ready, willing, and able to perform by virtue of the fact that the check was finally sent. Of course, the fact that the check was sent after the contract was terminated is, in our view, no evidence at all. They then argued that this phone message somehow constituted a tender of performance. But one of the cases we cited in our brief, Rissman versus Kilborn, involved a situation where a buyer took title subject to a few mortgages he was obligated to pay in addition to a mortgage he owed to the seller. In subsequent litigation, a dispute arose as to whether or not the buyer had actually paid those mortgage companies. The buyer contended he had by way of 2 or 3 letters that were sent to the mortgage company saying, hey, we got the money, we're ready to pay. And one of those letters specifically told the mortgage company, hey, the money, $116,978, whatever it was, is sitting in an account in XYZ Bank. We're ready to send that to you as soon as you tell us your instructions for disbursement. Tell us how you want to handle the satisfaction of the mortgage. The money's yours. We're ready, willing, and able to do that. The court in that case held that that did not constitute a legal tender of performance simply because there was no actual production of money. It was merely a written proposal to pay. In this case, of course, all we have is a phone message. So we would argue the point that the phone message constituted some sort of proposal to pay. Here, again, I think this is a case which really underscores the wisdom of deferring to the trial court's rulings. The judge really had to make a decision here on whether or not this offer, this phone message, really constituted an honest, legitimate effort by these buyers to comply. I think Mr. Costa's credibility, his testimony, was consistently in question through this trial, as evidenced by the fact that he testifies on direct, that he never got any requests, but then on cross he's saying, well, I did tell the broker I'd pay it, and he sent me a written request. So the trial judge had a tough time here, and I think it's absolutely essential to be able to observe firsthand the credit, the demeanor, the aspect of the witnesses to make that decision. In the end, I think it's fair to say this trial judge was not overly inclined to grant a broad degree of latitude to a buyer who is not only a lawyer, but a lawyer who is a seasoned real estate investor who was also playing fast and loose with the contract whenever it seemed to benefit them. The case law here, a few moments remaining to me, and I don't think I'll take all of my time. I think the case law here is helpful only to the extent that they provide general rules. I have no argument per se with the cases presented by the appellant as far as the general rule goes, but I would argue that the facts in those cases simply aren't appropriate here. The appellant cites cases which stand for the proposition that a seller can't use his own delay or lack of performance to argue that the buyer isn't entitled to specific performance. I have no problem with that. But the cases that the appellant have presented involve cases where the seller, in one instance, tried to extort extra funds from the buyer, the seller didn't show up for closing, or as in the Lance case, the seller simply didn't tell the buyer in advance that if you don't pay this deposit, the contract's going to be canceled. So I think those cases only go so far in being helpful. Even our own cases, I will be candid to say, are only helpful for general rules. It's well settled that a buyer in default or who hasn't complied with the contract is not entitled to specific performance. And certainly we would argue the case here is the buyer came into court with unclean hands and certainly failed to show that it was ready, willing, and able to perform under the contract. We respectfully ask that the court consider our arguments and affirm the judgment below in all respects. Thank you very much.
Thank you, counsel.
Thank you.
Let me ask you to respond to the argument that the timeline was
Absolutely.
admitted as substantive evidence without objection.
Mr. Downs testified that that timeline was created at his request after the events occurred when he asked Ms. Gregorian to prepare some list of what had occurred. I objected to it. He did not get it. I believe the record will show it was not admitted as evidence. It was submitted simply as a demonstrative exhibit because Ms. Gregorian wasn't there to testify that she said anything to anyone about that. It was simply, and it wasn't a business record because it wasn't created contemporaneously. Mr. Downs was not the custodian of the records. He asked her to prepare this for litigation. As far as the, very briefly, as far as the buyer being ready, willing, and able to pay, Mr. Downs testified when he got told by Philomena Gregorian that my clients had asked whether to send several checks now or wait a couple days, he knew they were trying to pay. That was his testimony. He knew they were trying to pay. And instead he told her, forget it, cancel their contract. After they were told it's canceled, it makes no sense for them to send the money. They've been told your contract's canceled, we won't take your money. But yet they did do it with a letter explaining what they believed to be a mistake on Downs' part. So we respectfully request that the court reverse this, find that it was not a reasonable termination on literally 2 days' notice with a question on the form of payment with the seller knowing. And what's really, I believe, dispositive here, COSTA testified. This was not rebutted. As soon as that contract was canceled and he called to find out what was happening, a new sales agent spoke with him because Gregorian had been fired, and he was offered to buy it at a substantially higher price. This is Downs, who doesn't want to do business with COSTA, offering to sell him the same unit at a higher price.
Thank you, counsel.
Thank you.
Okay, well argued, counsel, and that does it for the morning. So we'll be in recess until tomorrow.
Thank you.